campaign based upon shooting in Indianapolis. In other words, he's saying that he has a plan to reduce the violence. It's insulting when I saw what his plan is, but secondly, here's the problem. His political party is the reason we have the violence. They now give guns to every lunatic who wants them here. They passed a law last year, as you recall, no background check, so you'll be crazy as hell and get a gun. And so now we have a high percentage of people shooting each other with all these guns because we have no controls of guns. So I'm thinking, you run for mayor for a problem that your political party caused? Don't be insulted. But anyway, that's my initial comment today. But we have so many things occurring in DC until we need to start off by talking about DC. And we have our dean to talk about that justice on the Supreme Court, the longest tenured justice, Clarence Thomas. Hey, Dean, why is it that we have a Supreme Court sitting justice who get paid, look like millions of dollars and benefits from a billionaire?
Well, let me just say first, I'm honored and for your gracious invitation and to be on with these. You are correct, all of you superstars. And if you would allow me just to kind of framework, because you have a very sophisticated audience, and I teach professional responsibility and also investigate misconduct. And I think if you would permit me just very quickly to take a little space on to give the legal framework that perhaps will allow your listeners to glean what is going on, and also to continue this conversation. And when they're listening to all the chatter during the news cycle, that I think it would be helpful if I might. As you know, we're constrained as lawyers. I'm constrained by two dueling duties. One is that all lawyers are constrained by the American Bar Association rules of professional conduct as implemented in their states. Most have adopted most of that. And those rules say, and why this is just a timely discussion. Model Rule 8.2 says that every lawyer shall be constrained not to make reckless statements about the integrity of a judge. Some of these folks are trying to make everybody be quiet, because they say you're picking on him, you're busybody, etc. And our retort is that we are supposed to ensure that everyone in the profession and the judges are living by a professional code of conduct. Secondly, as we are constrained by being sure that we are not making reckless statements, we are under ABA Model Rule 8.3 required to report any possible misconduct. And 8.3 also says we have to do that if there is a substantial question as to judges' fitness for office. We have to report it. So some of this is we have a duty right now to have a conversation, certainly. And we want to inform your listeners, certainly. They have every right as informed citizens to understand what the framework is, and that they have every right to know what the controversy is. With respect to Supreme Court Justice Clarence Thomas and the other judges, significantly, the Supreme Court judges are not bound by any ethical rules, like all the other judges in every state, because the Supreme Court has declined repeatedly to adopt any ethics code. Therefore, there are no, if you will, for example, articulated standards to guide judges in determining when they should and must recuse themselves from any possible or actual conflicts of interest. And so people are leaning on that as, Well, they don't have a code that they have to adopt. They can basically do what they want. And, the Chief Justice Roberts can sort of have a conversation, but a judge can just say, a Supreme Court judge, the way no other judge or lawyer could say, I'm just going to ignore all of you. I'm making all my rules. I use my own judgment. One thing is important, that every other judge other than the Supreme Court judges are required not only to promote independence, integrity, and impartiality of the judiciary, they shall avoid impropriety and the appearance of impropriety. Now, that's a standard that we as, lawyers, we know that we're familiar with. It's even the appearance of it. And this is what we have that's bubbled up in this controversy. What is the controversy? That through some reporting, first by the Washington Post, the New York Times, but now fully by ProPublica, that there has been, in the view of some an unethical, and that's what other folks are saying, and we as lawyers know it's got to be proved up, impropriety in what the Supreme Court justice has received as allegedly personal gifts, which is what he's leaning on, but also in his relationships. So, for example, we first learned that a very wealthy donor billionaire had provided vacation times, homes, yachts, sailing around the Caribbean, which that was given provided to Jenny Thomas, and who's Clarence Thomas's wife, and him, and the then at that time Justice Thomas said, this is very old and dear friends, which you can under the rules allow very old and dear friends provide you, with gifts. So far as we know, nobody has received any such gifts at that, which they value to be over $500,000. The other thing, then he was very quiet when it was determined that this old friendship, which one would think had occurred before he took the bench, actually happened afterwards. And most folks say, that's when, remember Obama's rule was no new friends. The minute he got to the White House, no new friends, because that kept you from having other people. Now, that doesn't mean he did anything wrong, but your antenna, y'all, you know that you just kind of are careful about that. So he made these substantial, he got these substantial gifts. He said he didn't have to report them because he was advised by other judges when he took the bench, you didn't have to report, personal vacation trips by your friends. These are a little bit more exotic and expensive than one would normally think. And then it was revealed that this same billionaire, Harlan Crow, allegedly brought, and he has admitted, the home that was then occupied by Thomas's elderly mother. There's some view that maybe she's still there, maybe not. She's 94 years old, and that Crow purchased this from Thomas. There's still a little uncertainty there, for $133,000. And then he made certain repairs to it, et cetera, and to the roads, and bought some adjoining property. And that was at the value of tens of thousands of dollars. And again, under a federal disclosure law passed during the post-Watergate period, the real estate deal over, you had to, as even a Supreme Court justice, had to report over $1,000 in any real estate deal. He didn't do that at all. Because again, under this, someone told him he hasn't identified other judges. You don't have to report that. Then we find out this week that a grandnephew who Thomas has had legal custody over received to his tuition, and the tuition was paid by, again, Harlan Crow, for a time when he was going to private school and secondary school. And we know private school tuition is, high. There's been no disclosure exactly what the amount is, but it is believed that during that period, it is reported that there were 2 years of payments of roughly about $100,000. And Thomas's response to it was that he didn't disclose it because this was not a dependent child. And that just came out, I think, a couple of days ago. I don't know what that means. But then also we find that, again, there's this issue that has arisen regarding his wife, Ginny Thomas, who's always been a very active Republican operative and donor, that she was paid at least confirmed $25,000 by Leonard A. Leo, who used to be the head of the Federalist Society and still sits on the board for undisclosed work, but he made sure that it went through Kellyanne Conway's communications business. I know Kellyanne; she used to be one of my students, so that it went through that, and that, but don't put Ginny Thomas's name on anything. And he said that those who are trying to make much of this, the reason why he did it, because he knew part of it was people are just gossipy. Okay, but okay, welcome to being in the public square, right? But we know from before there was this issue about her communications and this relationship with Crow, certainly proceeded and may have been influenced by these trips that he took to Crow's private ranch, which is, we understand it, very extraordinary, before the Shelby County v. Holder decision in 2013, where the Supreme Court all of a sudden put a hold on one of the most important ways in which the civil rights, voting rights of African Americans were protected, that is pre-clearance. So all of these things sort of are here now. And of course, we don't prejudge it. We don't know whether it's true or not, especially, I'm here with defense counsel. They know that it's all whatever can be proved up. But that's what is now has led to certainly some changes. And as of, I believe, March 20 something, March 14th, there are new regulations that went into effect very quietly that apply to all federal judges, therefore the Supreme Court judges, that they must disclose gifts and free stays at commercial properties, or when gifts of hospitality, which is what allegedly was done by Crow to Thomas, are being reimbursed by a third party who is not the person providing it. So there's at least this, and Justice Thomas has said he will comply with this new rule of March 14th. Certainly, the Congress has decided, certainly on the Democratic side, that this is insufficient, that we need more. We don't know what people are doing and receiving. And there's nothing wrong with having very wealthy friends, but if you certainly can disclose it, but generally a judge would want to avoid even the appearance of impropriety, so that if one is sitting on the bench, let's just say hypothetically, I would not, if I was a judge, I'm just talking about me, if someone wanted to give me $1 million, I would probably say no, unless this is something being passed on to me by, my relative, and I'm the next one in line holding it for the family. But those are the questions. In my class, I've taught the students to say allegedly with respect to Jenny Thomas, because here's the collateral issue that, she's, telling her husband and influencing her husband and sharing confidences, and he's doing the same with her. And what we want to be careful as if we really develop all these rules. I don't think it's that hard, quite frankly, to implement them and to live by them, that the students were torn by this notion that half of the women that are graduating from law school right now, half of the people who are graduating from law school right now are women. And you can't just assume because they're in a relationship that they're coming home telling their husband and the husband sharing with them, who happens to be a judge, that everything that's going on. So there's some little caution there, but this is a controversy that I think that that certainly, and I'm glad you brought this up today. We don't want to just have the rules be made and the decision closed without us and your wonderful listeners and other folks of color just be on the sidelines because someone says that we're just picking on, the second Black jurist of the Supreme Court. And by the way, y'all just go away and be quiet, which some of the undertone people are feeling is you're saying we should be quiet because we just need to be quiet. And with that, I will open up the floor to you all asking me anything.
Well, wait a second, wait a couple. Attorney Banks, you had some specialized training. You did government relations for a major corporation. I mean, in that capacity, I was curious, is you ever heard anything such as outrageous? These trips are $500,000 on Gulfstream jet. I mean, that just, I don't know. Could you do that for a corporation and still not go to jail? I was just curious.
I've never heard of anything this outrageous. And as I mentioned on a prior show, Attorney Lee and colleagues, I'm just surprised that this has been going on for over 20 years and the story just broke 20 years later, right? And as Attorney Robinson so eloquently stated, there are rules of ethics for attorneys. We're governed by the ABA Code of Ethics and Standards, and there are rules of ethics for the executive branch as well. And as I've been talking to friends and fellow colleagues, we were in Springfield on Wednesday for another organization that I'm a member of, the Links Incorporated, which is an organization of 17,000 women that provide volunteer service, more than 1 million hours of volunteer service every year. We're talking about this case. And while there may not be any code of ethics, and by the way, these examples that we're hearing about with respect to Justice Thomas and others, Neil Gorsuch, we're hearing about all these land deals now and other examples. This is exactly why we need an ethics code for the Supreme Court. While there hasn't been any specific code of ethics, there is certainly a huge appearance of impropriety. And we must have, and the American people must have, faith and trust in our judicial system. And it must be perceived as being legitimate and fair in order for the people to subject themselves to it. Again, we were talking down in Springfield where if we go out to lunch with a staffer of one of the members of the Illinois legislature. And we can also use another example. I'm sure everybody knows the name of the 8-year special advisor to President Obama. You could not buy Valerie Jarrett a cup of coffee. You could not buy them lunch. Everybody on the state legislative staff in Springfield, we couldn't buy them a cup of coffee. So that's a long-winded way of answering your question, Attorney Lee, about what's appropriate in corporate. You know, and you have paid lobbyists, for example. You can't buy staff, legislative staff, or executive branch officials and staff. You can't buy them a cup of a latte. And so this is really serious. Their efforts now, I don't know, Attorney Robinson, if the legislation has been introduced yet to address what is a serious need for a code of ethics for for Supreme Court justices.
Attorney Grimes, you had the same type scandal with Tom Girardi out there in California. It seemed like, didn't you? I remember on one show you discussed that this lawyer that stole millions from people, and he wasn't the same type chummy relationship with some of the judges out there?
Well, he just happened to be caught, but I don't know if we've agreed that it's a wrong thing to do to give them vacations and jaunts to Las Vegas and invest in things that they do. I'm gonna ask Ms. Robinson a question. Yeah, we had that situation,
Right.
And Tom created a real ugly wound to the Bar Association out here. As you know, there was an article down in the LA Times that minority lawyers and especially Black lawyers suffer from any appearance of impropriety.
Correct. Agreed.
As opposed to white lawyers, you got to have actual evidence and prove beyond a reasonable doubt, damn near, to prove impropriety. But that's another matter. But what I do want to say about what Ms. Robinson so eloquently stated, my experience has been that it's not just the Supreme Court. It's down to the district court in the federal system, because I had an experience with Judge Davis in the Rodney King case. He wouldn't remove himself from the case, even though we had information, evidence, and transcripts of some of his comments about different parties in the case and different issues in the case, that we thought it was I did naively thought it was thought it was a simple thing to do, is just file an affidavit of prejudice and he would remove himself because of this, and that. He said, no. I said, well, we got to have a hearing. And they're not having a hearing. I'm not removing myself. And then that was the end of it. He's not required to remove himself, even with an appearance of conflict or some interest in the case. The law doesn't require it in the federal system. So it's down to the trial court level. They are self-controlling, they are self-managing. I went to Judge Hatter, who was the presiding judge in the federal system here in LA once, when a federal judge hired me to represent him because another federal judge had taken his case away from him involving a statement that he had made against a certain police department. And the presiding judge told me, Milton, there's nothing I can do. I said, but you're the presiding, you control, you manage, you direct. He said, no, I don't. They are autonomous. They do what they want to do in their courtroom. I have no control over it. I'm not, am I on point, Ms. Robinson?
Yes.
Okay.
You're absolutely correct.
They run their ship independent of each other, independent of the presiding, Nate. We have a messed up system that we so obediently bow down to here in this country, dealing especially with the federal system. We can paper a state court judge one time, kick them off the case, preemptory kickoff or for cause, for cause all the time, but one preemptory, you don't have that in the federal system. They're on there, and they set immune from you removing them from the court, even though you believe that they are unfair and are biased in your particular matter. So all this is beautiful sounding law about the appearance of impropriety and actual impropriety, et cetera, and what they can and can't do, but they do damn near what they want to do, and nothing can be done about it. At the
Before we move forward, we have about 12 callers on the line. And so this topic apparently has gotten a firestorm of comments. So when we have you comment, we have a few calls, then we'll get back to our guests. Keep it to a minute or so because we have a dozen of you guys. So we'll take one quick caller now. Caller, you have a question for us? A comment?
Hello,
Yes,
Brother
how you
Nate.
doing?
Yes.
Okay, I was just listening to the lady, and I appreciate her explaining this stuff. But I want to ask the question: when it comes to conflicts of interest, if attorney tell you on your way to arbitration and you on disability, but the court can told you you can get a light duty job, you follow me so far?
Yes.
And my lawyer told me if the judge asks you, have you been working, tell him no. Guess what? The court that said I could get a light duty job. My light duty job was instructing guys how to drive trucks, sitting on the passenger side and just telling them how to do. Now, you can't get no more easier job than that. And when I didn't tell a lie. He told me to tell him I wasn't working, but I was working. And they threw me in jail, talking about I hindered myself or whatever you call it when you don't tell the truth. Is that legal?
You should not commit perjury under any circumstances in a courtroom. And I'm a criminal lawyer, civil rights lawyer, but I have a standard myself that I'm not going to lie in the court. I can accept the truth. I think I can explain the truth and just give me the truth.
With that problem, and I spent the night in jail in Birmingham because I told the truth. The judge throwed it out the next day because I hadn't perjured myself unless
Right.
you got a word they call telling the truth.
Okay, next caller real quickly.
But is that legal?
Hello, Brother Nate.
Yes.
Brother Imhotep here. I'll be real quick. Commenting on the attack and fascism of our democracy, Judge Michael Ludick, quote from him, CNN, said that there needs to be a binding code of conduct for justice, quote, ought not to be thought of as anything more or certainly nothing less than the housekeeping that is necessary to maintain a republic. When I listen to Attorney Grimes talk, this republic is teetering on disaster. And it's just teetering on disaster. It's many cases we've seen of judges doing exactly what they want to do in the courtroom. And so this problem is far and wide. We've seen it from the Innocence Project, talking about getting guys that have been convicted out for crimes they didn't commit and procedures that wasn't followed, prosecutorial-wise or whatever in the courtroom. So this is a large-scale issue, and I believe that there are a lot bought off. But I want to ask your Attorney Banks, if you can help me with this. Texas is trying to force public classrooms to put the 10 Commandments in there, provide 30 minutes for prayer, and reading their particular religious book. I heard debate on this from Texas, their state house yesterday, and many thought this was unconstitutional. Can you explain to people on this station, since this is a religious station, and many here think that they took prayer out of classrooms, which was not the case, that the state cannot sanction one religion over another. Can you explain how this is just a harbinger for bad things to come? And thanks for taking my call.
It may well be, and I can say that I have not followed those Texas developments this week.
Well, the problem is, it seems like they have these crazy laws popping up every day. You need a calculator to keep track of them anymore. I mean, every day they have these draconian laws that are popping up in different states. overthrowing of the Roe versus Wade case. So we see an assault on women's rights all over. And then we see assault on certain type of separation of church and state. So the idea, though, is that at the end of the day, we got to make sure everybody get out and vote to get rid of these right-wing extreme and MAGA folks. Marjorie Taylor Greene, it seemed like she's running the Republican Party now, genuine nutcase. So that's my thought process. Now we'll take one more call, then we go back to our guest. Caller, quick comment. And I'm sorry that we have such a large wait today, but apparently we got a lot of people want to express their opinion today. Okay, you had a question coming, caller. Oh, producer, we lose them? Okay. Well, I want to move on to a second topic today because it's obvious based on Dean's presentation that taking millions of dollars from a donor just stinks. Okay, now I'm a producer. Okay, we'll take the caller now. Okay, caller, you have a question or comment? Ron, go ahead.
Attorney and friends, wishing you all the best. I had a comment. Yesterday I was listening and one of the callers called in about the incident in New York on the train where the gentleman was put into a chokehold and subsequently died. There's a group of people who want to believe that the young man should not have done anything and otherwise, there are a group of people who believe that this man killed the man without any disregard. And I don't think that that's what happened. I think you run into a bad habit or run into a problem when you've got an ex-Marine who is trained in hand-to-hand combat, unfortunately put someone in a chokehold, and unfortunately now the young man has died. I don't believe that that was his intent, and I'm sorry for that young man and his family, but I don't believe that there was any malice involved in this. Whenever, and I'll give you a for instance, when we had the shooter here in Indianapolis, or in, what was that, Greenwood? When there was a man in Greenwood shooting people with a gun, another young man pulled out his gun and killed that young man. For me, that was him taking out a threat. So for whatever happened, and there's a lot of people who are going to have to wind up in court maybe to testify as to what caused this young man to be put into a chokehold. And there's
Ron, let me correct you on something. Ron, there's something very important. All special ops in the military, when I was in the military, they were taught this chokehold. It's a position, it's a form of Brazilian martial arts, right? So when you put that chokehold on, within 90 seconds, the person should be unconscious. For 3 minutes, it should kill a person. So in other words, that chokehold is designed for deadly force. And you taught that as part of special training. I had the training when I was in military special ops. And so the person who did that knew exactly what he was doing, because he would have known that after 3 minutes, you should die. Because, so in other words, it's not an accidental death. Now, I'm not sure what motivated him to do it, but there's nothing about that type of chokehold is accidental. And it is a specific procedure that is taught in the military, and it's part of your training, it's hand-to-hand combat. And it's done by simply putting your left hand in your elbow, putting your right hand behind the person's head. And when you squeeze, when the person tried to escape, they actually cut off their oxygen. So even if they tried to escape from this maneuver, it is make it more deadly. And so you know that, but you're taught to just do it long enough to get the person unconscious if you're not trying to kill them. So when you're doing the training, you can't do it more than 90 seconds because they know it could kill your soldier. So it's not an accident, okay?
When it comes to the court case, and even the what do you call them? The prosecutor is going to investigate and decide whether or not this young man did something wrong. There's going to be enough witnesses there. They got videotape. I hope this pans out, but I don't want to just think that his intent was to do harm to someone. I would rather believe his intent was to try to take out a threat, put a threat down, but something went wrong. And I'm hoping that while we're busy judging, I'm hoping that the prosecutor and the tapes and the witnesses, you got a train full of people. I've been on the train in New York, so I'm kind of sure there's a lot of people who saw this, and hopefully it will be not adjudicated, but more investigated and determined whether or not this young man should be held accountable in some way.
Thanks, Ron. Okay, one final call, then we get back. Lisa, one final comment, then we get back to our top of the day. Lisa, you had a quick comment for us. Hello, producer? Lisa? Yes, go ahead. Yes, ma'am, go ahead.
Can you hear me?
Yes, I can.
Okay. My question is, have they just done something wrong in a criminal case and say that they ruled it justified, but it turns out that they didn't go by the guidelines protocol on the case, but it's been 8 years. What will happen to that police officer knowing that he didn't go by protocol guidelines? After what evidence, he falsified records, but probably retired now. What will happen with the court?
So your question is essentially a police officer engaged in misconduct as it relates to a defendant's rights in a criminal case? Is that it?
Yes. Yes.
So did the police officer commit perjury? And did the police officer commit perjury or fabricated charges against an innocent person?
Okay, what it was a domestic. It was domestic. Ended up in being a murder case. Would it justify officer a protocol or the guy?
Well, I don't understand. Are you saying that the police officer lied when he went to court? Is that the issue?
Well, they so much went to court. I know say that comes on the case, okay? Say that the person say, oh well.
Okay.
And at the same token, this person was home. So when the
Okay, I apologize. I'm not understanding you. So there's a communication.
The call log was erased. So we was like, well, how was this call log erased? At the phone, it had a lock.
Okay, I can't. They call it. I can't answer that because I don't understand the question. But let's get back to the second topic because I know we got a lot of callers, but there's a couple of things that we need to cover today also. We had the Pride Bar trial in DC also, that it was a monumental verdict this week. 4 of the Proud Boys were found guilty, and Enrique Torres, who's the leader, was not even in part of the process. He was not even in DC, and he was convicted. And but Attorney Grimes, I was just curious. It's conspiracy and stuff, and they had a lot of evidence they put on the news and things like that. But how successful are these convictions when a person is convicted of conspiracy, was not even in DC at the time? How difficult is that in terms of defending it or prosecuting it?
Nate, I think we saw an example of that in the case we talked about, maybe it was a year ago, with Judge Answer Haggerty, a federal judge out of Portland, Oregon. which is over the Tom Metzler case, if you recall, where some disciples of Mr. Metzler, who was the head of the Aryan Brotherhood or white hate organization based in Southern California, and he had espoused hatred and that violence should be used against minority people and the Africans and should be sent back to Africa, etc. And two of his disciples in Portland, Oregon, 1,000 miles away or so, saw an Ethiopian young man who had just gotten over here from to this country, and they beat him up and killed him. And there, the jury held Metzger responsible because he had incited these young men to do the violence that they did that resulted in a death. That was, and they found him liable, and I think it was $11 million, $13 million verdict. In the criminal law, if you conspire or you get with a group of people and you agree or they agree to do something, you don't have to be physically there when they do it to be liable. And I think that's how Mr. Torres reached his conviction. Now, Vanita may have an explanation as to why he shouldn't have been convicted. I think that she knows more about those people than I do. Maybe she can comment on it.
Well, these defendants, some of them, they claim credit for the insurrection, on social media and in chat boxes, as well. So that was some of the evidence that led to the conviction of 4 of these.
But did it come out that he had planned, organized, or instigated anything about their activity, Vanita?
Absolutely. They
That's how he
were
got
convicted of seditious conspiracy and conspiracy to obstruct an official proceeding, and specifically conspiring to forcibly stop the lawful transfer of presidential power. And the jury listened to evidence for nearly 4 months in this case. And I'll also point out that since January 6th, that more than 1,000 people have been arrested in nearly all 50 states for crimes related to the breach of the U.S. Capitol, including more than 300 that have been accused of assaulting or impeding law enforcement. And so these defendants were convicted of leading a group of Proud Boys and others onto the Capitol, where they dismantled metal barricades, they destroyed property, and they assaulted law enforcement. And much of the evidence, or some of the evidence, was based on their chatter over, their proud chatter over social media.
Well, they were following the commands of our leader, right? The President of the United States. And it seemed like there's some defense.
That's the defense that many of them have been making, that they were following the demands, the instruction, the direction of the former president of the United States. And you'll remember him leading the rally where he called out, what did he say? Stand back and stand firm, something to that effect.
He said, Proud Boy, stand back, stand down.
Ms. Robinson, aren't
Yes, sir.
I entitled to the defense of following the directions and the orders of my leader? Isn't it called ministerial or some kind of defense that you can use when you're following your command, like when Nate was in there?
Yeah, absolutely. And but that doesn't cover all of us as citizens when we're just walking around. We're not in the military. We're not following a chain of command. And part of this, that we have to add in the mix is that, in fact, the military leadership was sitting in the Pentagon and had already, as we understand, if this is true, had conversations with the leaders of Congress that they would not take an order that they considered to be unlawful, that order being that the then President Trump would not cede power, that he would hold on to power unlawfully using the military. That conversation had occurred earlier, and that the Speaker of the House specifically asked the Joint Chiefs. I'm hearing chatter, I'm hearing things, and you'll remember, Nate.
You froze so much. She's frozen.
Attorney
Yeah,
Robinson is frozen.
Yeah, she has an internet
but
interruption.
my commander-in-chief has pretty much ordered me to take action. And as a citizen of this country, do I not have the justification to take action as ordered by my commander-in-chief under this exceptional circumstance?
I
Well,
don't know if you can hear me.
there she goes.
Now we hear you now.
now.
Yeah,
Go ahead.
that the order has to come from the commander-in-chief to people who are in the military, who are below them. These folks were not that. And the military, and I'll just say it very quickly, had all the chiefs of the military, those folks in leadership had already assured at least Speaker Pelosi and others that they would not, and this is what the days before, would not accept an order, what they consider to be unlawful order by President Trump to hold on to power and to lead an insurrection.
But as the line man, I haven't heard that discussion, so I'm following the direct order of my commander-in-chief, because I haven't been part of that discussion where the
Right.
military was too cowardly to protect him and follow his command.
I understand that, but as a civilian, we don't have any right to decide that someone that the president says, go to the Capitol, take it over. We're civilians. We're not in that chain of command. But I'll tell you this, most of the story has to do with, what the people who came to the city, those of us who were in the city were sitting, some of our children were in the Capitol calling in and saying, pray for me. Some of my students, I don't think I'm going to make it out of here. That's how bad it was. So what I'm saying is that we do have to ask that everybody be lawful. The Proud Boys, I understand you got confused. He told you to wait. He would tell you to come. You made a decision that you should not have, but everybody has to be lawful. These guys afterwards and before, they were sitting, and Nate, you know this, they were sitting across the street from the White House in the Mayflower, that the first floor, Vanita, as well, and you probably do as well. They were sitting down there, chucking it back, having a good time at the bar, talking about what they're going to do, talking about how great it was. And we have police officers, there are over 100 that suffered physically.
But this country was founded on the understanding and the concept that the power lies in the people. And that's what we had to do in England,
exactly.
The power in the law. So why not be able to do this now?
The courts are not buying that defense, Attorney Grimes, because the DOJ, the Department of Justice, has secured more than 600 convictions for a wide range of conduct resulting from the January 6th insurrection. This week, we saw, just 2 days ago, the longest sentence being handed down of 14.2 years. A Peter Schwartz, a 49-year-old welder from Pennsylvania. He used pepper spray. He was the first to throw a chair at officers who were protecting the Capitol. He received the midpoint of the sentencing guidelines, which would have been 24 years. He received 14 years this week, which is, and this judge had earlier handed down the previous longest sentence of 10 years. So we're seeing that defense not carry the day, Attorney Grimes.
Thankfully, that's why we got the Court of Appeal and then ultimately the Supreme Court that will decide this right.
You know what? I was on, gave notice that I was going to be needed for jury for, I believe it was 2 months. And I knew these cases were coming up. And I had dear friends who prosecutors said, don't even put in for leave. You ain't getting on none of those juries. The great defense counsel will have you excluded. It's not going to happen. And it didn't. So, I believe in the justice system, but I believe the rules apply to everyone. And, they made the mistake of coming here and the Proud Boy leaders were proud that they were lifted up by the former president. They were always proud of that. And if they had taken over the Capitol and then Washington, D.C., woof.
They're quoted to have been, quote, soldiers against democracy. And so we'd always wondered in the immediate aftermath of January 6th, whether anyone would be held accountable. And we're seeing over 1,000 people have been arrested. We've seen to date over 600 convictions and more to follow.
Well,
unfortunately-
Milton, tell them to give them your number so you can go help them out and make that argument that's not they need a closing argument for the jury.
Well, I like to thank each and every one of our superstar panel today. We've had an interesting show, and I'm sorry that we could not reach all the callers today. I know that we had some hot button topics today. There's some other topics that we didn't get to today. I want to talk about the Dominion voting lawsuit and the ramification of the First Amendment and things like that. So you have to join us next week. We're going to continue this discussion. I'd like to thank each and every one of you for calling in today. And I'm sorry the ones that I didn't. And you can always also go to a website and make a notation. And when you see me out and about, just keep the conversation 2 minutes. I don't mind talking to you. Thank you, everyone. And may God bless and keep you. And thank you, our special host today. Goodbye, everyone.
Bye, Vanita. Can't see you waving.
Bye.
Bye. Bye. Bye, Ms.
God
Rock.
bless.